Peace, family. This is Lions Den with another news and commentary. I updated a video just not too long ago about a black man who's at a convenience store. Bought a candy bar for his 5-year-old son, and this white supremacist confronted his girlfriend over a handicapped parking space. So a black guy pushed this white guy, and all of a sudden he pulled out a gun and shot and killed him. Well, this sheriff's department right here is issuing a press conference saying that the guy that killed that black man possibly will walk thanks to Stand Your Ground law. So we can go ahead and play this press conference. And again, thanks to Phil from the Advise Show for this video. So I'm going to go ahead and play this video and give you the rest of my commentary.
Nonetheless, is that we don't build it, we just sail it. So what I mean by that is that I don't make the law, I enforce the law, and I have to apply the facts of every situation to the law as the legislature has passed it and as the governor has signed bills enacting it. And the law in the state of Florida today is that people have a right to stand their ground and have a right to defend themselves when they believe that they are in harm. So we'll talk more about that. But that's against the backdrop that this situation has to be evaluated and has to be considered. So at about 3:30 yesterday afternoon, the Pinellas County Sheriff's Office responded to the Circle A convenience store at 1201 Sunset Point Road in Clearwater. And what we know from the investigation is that Marquise McLaughlin, who's a 28-year-old African-American male, had arrived at the store with his girlfriend, Brittany Jacobs. Brittany parked their car in a handicapped spot by the store. Marquise and his son, who's 5 years old, went into the store. Another person by the name of Michael Drejka, who's 47 years old, white male, arrived at the store. He lives in the area and was a frequent customer of the store. And somebody who others have said complained about people parking in the handicapped spots. And he had an issue with people who illegally parked in handicapped spots at that store. So apparently Drejka gets out of his car and is checking around Jacob's car and looking for handicap decals or permits or anything that would authorize them to park where they did. When he didn't see that, he confronted Jacobs, and by all accounts is that they got into a pretty significant yelling match. And there was no physical violence, there was no threats, but it was a disturbance, and that they were yelling at each other, and he was complaining about her parking in the handicapped spot. There was another customer there at the store, and the customer went inside and told a store employee that there was a disturbance in the parking lot and that he should do something about it, which was interpreted to mean probably call the police. At that point, Marquise McLaughlin was in the store and learned of the disturbance in the parking lot. It appears that he learned that it was his girlfriend, Brittany Jacobs, who was involved in this verbal altercation with Drejka. So he exits the store. And when he exits the store, and it is captured on video, and we'll show you the video here in a second, he walks out the door and walks straight toward, meaning Drejka, walks straight toward McLaughlin. And by all witness accounts, there was no verbalization. There were no statements that were exchanged between McLaughlin and Drejka. Let the video pretty much speak for itself, but I'll characterize it this way is that McLaughlin approached Drejka. He didn't waste any time getting to him, and then he pushed him, but it isn't just a push. He really slammed him to the ground is what it is. And he pushed him with great force. I mean, this is a violent push. This wasn't a shove. This wasn't just a tap. It was with his hands, and he slammed him to the ground. So Drejka falls back. And as Drejka falls back, he is on his rear end on the ground. And at that point, McLaughlin is still a few feet away. McLaughlin is facing Drejka, and Drejka is on the ground. And when Drejka had been slammed to the ground, he then reaches, because he's a concealed carry permit holder, and he can lawfully carry a concealed firearm, he reaches and takes out his firearm. And at that point, McLaughlin is still, again, a few feet away. He's facing Drejka. Looks like he's starting to turn a little bit, maybe as we would call blading, which is kind of at an angle, but he's not turned away. He's still facing. And at that point, Drejka fires one round from the gun, and it strikes McLaughlin right here in the chest. McLaughlin then grabs his chest and retreats back into the store, where he collapses. EMS responded. He was taken to Morton Plant Hospital, where he was pronounced dead. Drejka, after he shot McLaughlin, took his firearm, put it in his car, and waited for law enforcement to respond. Drejka was cooperative, and during the interview, what he claimed is that he had a verbal altercation, he was approached, he was slammed to the ground, and that he was in fear. And he felt, after being slammed to the ground, that the next thing was that he was going to be further attacked by McLaughlin. And that he was focused on McLaughlin's lower body, really couldn't see his hands, but he felt that the next thing was that he was going to be slammed again and going to be struck again, and that he was in fear. So why don't we just, it's very short, play the video for you, and then I'll continue on. So why don't we go ahead and do that?
For video TV purposes, how much are you showing?
I'm going to show you the whole thing. I mean, it's short. I mean, it's not even 15, probably 15, 20 seconds, maybe tops. It's short.
Up to the part where he's shot?
Oh, you're going to see a shot. You're going to see him shot.
Yeah, we can't. We don't want to show that.
Okay, well, there's no way to do it other than you really can't see. You can see him clutch his chest. That's about all you can. That's about all you can see. I mean, you're not going to see the. There's no blood or anything. You guys can edit out what you want. But that's the car pulling in over there. Okay, so this is a little longer version.
Sheriff, can you give me a warning right before it actually happens?
Yeah.
Okay.
Yeah, just so we can pull away.
Sure. So that's Drejka approaching Jacobs. And you can see he's looking around the car. And he's looking for the handicap permit decal. Okay, so this is McLaughlin coming out. So he's getting ready to push him, and then the shot's going to be fired. And right here. Okay, so that's the video. So if you count it, between the time the Drejka goes to the ground and the time he shoots, it's a count of 4 seconds. It's a count of 4, no more than 5. It's a very short amount of time. And what he claims, and you can tell, it's a violent push to the ground. This isn't just a shove. I mean, he slammed him to the ground. And he said when he's on the ground, because he's in fear, that the next thing that's going to happen is he's going to be re-attacked by McLaughlin, and he felt that he was at peril and that he needed to shoot to defend himself. McLaughlin was still standing there. He was still in front of him. He had the ability, the capability to do again or worse what he had already done by pushing him to the ground. As I said, there's no verbalization between either McLaughlin or by Drejka during this. And the law on stand your ground is clear, and the Florida legislature has spoken on this. And the Florida legislature has created a standard that is a largely subjective standard. This is not an objective, what I would do, what you would do, what the public would do, what somebody else would do. This is more of a subjective standard, and the person's subjective determination of the circumstance they were in, the fear that they had, is relevant to the determination of whether they're justified in the use of force. So under these circumstances, where you have somebody that is unprovoked, slammed to the ground like that, and his statement that he believed that McLaughlin was going to come back at him, and he fired in a very short amount of time, a few seconds, 4 seconds probably, somewhere in that range. That is within the bookends of stand your ground, and within the bookends of force being justified. And the immunity that people are granted under the stand your ground law is just not an immunity from being charged, not just an immunity from being convicted, but it is an immunity from arrest. And I'm going to read this to you, and this is Florida Statute 776.032, and here's what it says under paragraph 2. A law enforcement agency may use standard procedures for investigating the use or threatened use of force as described in subsection 1, but the agency may not arrest the person for using or threatening to use force unless it determines there's probable cause that the force that was used or threatened was unlawful. So we're precluded from making an arrest in this type of a situation. Then it goes on to say that the court shall award a reasonable attorney's fees, court costs, compensation for loss of income, and all expenses incurred by the defendant in defense of any civil action brought by the plaintiff if the court finds that the defendant was immune from prosecution. So, one, we got to follow the law. Two, if we don't follow the law, we're civilly liable for not following the requirements of Florida stand your ground law. Importantly, the legislature this session changed the framework for stand your ground. The framework for stand your ground used to be that the defendant had to raise stand your ground as a defense, and the defendant had the burden of proving that they were entitled to immunity under stand your ground. And the legislature changed the law, and the law now is that the state attorney has the burden of proof by clear and convincing evidence that the defendant, the shooter, is not entitled to stand your ground. Nowhere else is there anything like this in criminal law where that somebody asserts something and the burden then proves to the other person or shifts to the other person. So the law is changed dramatically because you've got a situation here where stand your ground allows for a subjective belief by the person that they are in harm's way, they're in fear. In this case, this guy was slammed to the ground. In very short order, he felt it necessary, felt it necessary to defend himself because he felt he was going to be attacked again. And in order for him not to be justified, you have to take it outside of those bookends. And we are precluded from making an arrest unless we have probable cause that the person committed a crime, and we don't have probable cause here of that. And even if we were to charge, or if the state attorney were to charge, all he has to do is say, stand your ground, and then the state attorney has the burden of proof by clear and convincing evidence at a stand your ground hearing that he is not entitled to stand your ground immunity. And that's a very heavy standard, and it puts the burden on the state. So under these circumstances is that we cannot make an arrest. We're going to refer this to the state attorney's office. The state attorney's office will review it and apply the law to the facts and make a determination as to whether something should be charged. You know, before stand your ground, a case like this probably would have a different outcome. You know, as you can see in there, there is a pause, even if it's only for a couple seconds. There is a pause between the time Drejka hits the ground and he shoots. That pause gives me pause. That pause gives me some concern. And it goes back to what I said when I opened. Just because you can doesn't mean you should. But I don't get to, and we don't get to, substitute our judgment for Drejka's judgment. My question is, and what I have to do is make a determination, applying the law to the facts. Is he within the framework of what the law allowed him to do? Does this law create a situation potentially where people shoot first and ask questions later? Well, you can have that discussion. You can have that debate. I don't make the law. We enforce the law, and I'm going to enforce it the way it's written, the way the legislature's intended for it to be applied, and others can have the debate about whether they like it or not. So this will go to the state attorney. Drejka will not be charged. He will not be arrested by us because we're precluded from effecting an arrest. The state attorney will view it, and either he'll concur or not. And if he concurs, then there'll be no charge, period. If he doesn't concur, then he'll make a determination as to what to do with it. And if he feels like that he can overcome that heavy burden at a stand your ground hearing of proving by clear and convincing evidence that Drejka was not entitled to use force in this circumstance, then that's the state attorney's determination to make. I just ask everybody to understand, and there are a whole bunch of people I know and I've already got emails about it. People are already starting to voice concern over this, and I understand that. I don't make the law, but I will enforce the law, and I'll enforce it fairly as the legislature has directed that it be enforced. And under these circumstances, this fits within the framework that the Florida legislature has crafted for all of us to live by in the state. I'll take any questions that you have.
So you talked about that pause when he pushed him to the ground. There you counted 4 seconds, Sheriff, but he's not coming after him during that pause.
Doesn't matter.
Show any more aggression. Can you kind of go?
It doesn't matter because this guy's on the ground, and you know, no matter how you slice it or dice it, that was a violent push to the ground. That was a slam to the ground. So he pushed him to the ground. He violently goes back on the ground, and he's sitting there. He takes the gun out, and what he's seeing and what he's saying in his mind is the next thing he's thinking is this guy's going to come at me again, and he fires. And is that within the bookends of a reasonable belief on his part under those circumstances of that time? Yeah, it's within the bookends. Now, You can say, is it on the fringe of the bookends? I don't know. I'll leave that to others to judge. But is it within the bookends? Is he legitimately, could he be in fear after that violent slam to the ground? Could he be in fear that the next thing is this guy's coming at him again when the guy's standing right there and he's standing right there like this? Yes, he could. And, you know, could he have said, hold him at gunpoint? And you could cut that both ways. He could hold him at gunpoint and not fire. Yeah, he probably could have done that. But also, the fact that he's holding him at gunpoint could also cut towards his legitimate fear. And, you know, the guy didn't turn around and run away real fast. And the guy didn't do anything. He said, hey, man, don't, you know, we're good or something. He didn't do any of that. So it cuts towards this guy's belief in his mind that he's going to be harmed again, and he had to shoot to defend himself. You know, and those are the facts, and that's the law.
But there were no direct words between the two men that you know of.
They didn't, no. And I'm not going to get into altering the facts, because altering the facts alters the outcome. But if you were to engage in that exercise, and you were to alter the facts further to the left or further to the right, and you were to change this scenario, it could have a different outcome. And if there were an exchange of information, and if the exchange of information was Marquise McLaughlin making threats to him, verbalizing and saying things that buttressed his belief that he was in harm and imminent harm, then that cuts more towards justifying the shooting. If Marquise McLaughlin was saying stuff like, hey, man, we're good, and, you know, forget about all this, then it cuts the other way. If you have longer time, like 8 or 10 or 15 or 20 or seconds, and McLaughlin had turned away, well, then that changes the outcome. But we can't change the outcome. We cannot change the facts. The facts is that he approached him, slammed him to the ground, and within about a 4 count, he fired. And no words were exchanged. We've got to use only the facts, and the facts are clear based upon video and eyewitness accounts.
Speaking to the owner of the store, he tells us that the man who fired the shots is a nuisance there, that he's caused problems in the past with other people. Do you know, are you familiar with this person? Have you been called there to deal with problems that he started in the past?
Yeah, I'm not aware, Holly, that we have been called there to deal with him in the past. There have been some incidents in the past, and we're aware of those incidents. But what's material here is what happened at that instant. You know, we have to recognize that if Marquise McLaughlin hadn't walked up to him the way he did and slammed him on the ground, we wouldn't be here having this discussion either. So what's relevant is not whether this guy's a good guy, nice guy, or whether he's a jerk, or whether he's a thorn in people's sides, and what he's done, whether it's 3 weeks ago, 3 months ago, or 3 years ago. What's relevant, and the only thing that we can look at here is, was he in fear of further bodily harm because of what Marquise McLaughlin did, and was he in an ability and have the capability to carry it out? And the answer is yes. So that's what we got to look at. And I'm not saying that this guy, he might well be a thorn in people's side. He might be a jerk. He might be all of those things. That doesn't matter. That doesn't matter. What matters is, did McLaughlin slam him to the ground? Yeah, he did. And was this guy put on his rear end? And was McLaughlin standing over him and in a position to do what he thinks McLaughlin was getting ready to do, which was to come at him again and harm him further? Yes. And does Florida law allow you to defend yourself and stand your ground? It does. That's what the Florida legislature has said. And so, you know, our job and our role is not to substitute our judgment for the law and what the legislature has crafted as a framework, but to enforce it equally and fairly as we're required to do. I'm not saying I agree with it, but I don't make that call.
Do you disagree with it? Would you come out and say you disagree with it?
Well, I'll say this, is that I am a firm believer in the adage that just because you can doesn't mean you should. But I'll also say this, is I'm not going to substitute my judgment for Drejka's judgment sitting on that ground after having been slammed to the ground either. And, you know, and from his perspective, sitting there on the ground, and within a few seconds, literally, because he took the gun out and he made a decision. So it really doesn't matter what I would have done or what anybody else would have done. And would I have done something different? There's a difference between arguably too what a what a law enforcement officer would do. And this guy's not. He's just a citizen. And he felt he had to defend himself.
But Sheriff, where does the law come into play where he's running out thinking that his family is being threatened and he feels like he has to defend his family?
There's no evidence of that. And again, that's what you got to be real careful with. You can't, and I get the tendency, but you can't impute facts that don't exist. And there is no evidence, no testimony, no witness accounts that his family was in harm's way at all. It was purely verbal. Purely verbal. And by all accounts, there was not even any threats. They're just arguing back and forth about the handicap spot. And I'm guessing, but we can't unfortunately talk to Marquise because he's deceased, is what was going through his mind. He probably didn't like the fact, and I don't think it takes a giant leap to get there. He didn't like the fact the way this guy was talking to his girlfriend. But also, Marquise shouldn't have gone up and slammed him to the ground either. He should have said, look, man, knock it off. He didn't have a right. Marquise engaged in unlawful conduct himself. Marquise should not have gone up and slammed this guy to the ground. And Marquise wouldn't be dead if Marquise didn't slam this guy to the ground. So, Marquise has got skin in this game too. And the reason why it makes it justified and within the framework of stand your ground is because of what Marquise did. It's sad. It's really sad. And again, we can have a discussion about what we would have done or what the law would be or what we would have done under the law prior to stand your ground or prior to even the change that puts the burden on the state and makes it a clear and convincing evidence standard. We can have those hypothetical discussions all day long, but I don't live in a hypothetical world. I live in a world of what's the law, what are the facts, and how are we going to apply it as directed? And that's what we have to do.
But are you frustrated with, especially this change now that puts the burden of proof on the state attorney? Can you tell us if that frustrates you and your job?
It's a mixed bag, I'd say. There are times, look, people should be able to defend themselves. They should. There are times, and I can give you, again, we can come up with situations and scenarios where I do believe that stand your ground has its place. And I think that it can be something that is properly used. So as an example, before stand your ground, if somebody's walking in the mall parking lot and somebody comes up and attacks them, is that they're required to make an effort at least or reasonably retreat before they can use force. I don't think if somebody comes up to you in the mall parking lot and tries to rob you, that before you can use force and defend yourself, that you should be required, there should be a requirement in the law to retreat first. Then you get the other end of the spectrum, which, somebody can certainly make the case that maybe this guy could have handled this differently. But, so that's why you got a range, and you got bookends. And you're going to have things that fall toward one end of the bookend or the other that aren't squarely in the middle. And I think there's an argument this probably falls towards maybe one end of the bookend, but it doesn't take it outside the bookend. And it doesn't mean that you throw the baby out with the bathwater. And I see where there can be benefit and the right thing for people to be able to protect themselves. Look, nobody has a right to harm somebody else. Nobody has a right to commit a crime against somebody else. And no matter how you slice it, dice it, or otherwise, you got to come back to is that Marquise McLaughlin wouldn't be dead unless Marquise McLaughlin slammed this guy to the ground. And, don't put your hands on people. Don't slam them to the ground. And if you do, you're taking a chance that that person might be a concealed carry permit holder, and they may decide that they're in fear and they're going to defend themselves. That's not, that's the world we live in. So don't slam people to the ground. People have a right to do that, to defend themselves.
How long you may not know this question, but how long do we think the state attorney's office is going to have with this investigation?
I have no way of knowing that. I can't comment on that. It'll take us a few days to package it all up and to do all the reports and to get everything together and then submit it to them. And then the state attorney will conduct his own investigation and evaluate it. But I can tell you that it's not going to be short order. I mean, if that's what you're asking, are we talking, hours or days? Are we talking weeks or months? Well, it's not hours or days, and that'll be up to the state attorney to make that determination. But I think it'll take them some time to evaluate it. Anything else? Okay. All right. Yep.
Okay, people, you just watched the Pinellas County Sheriff's press conference of the incident that happened that I reported earlier and what Phil from the Advice Show reported earlier. And by the way, thanks for Phil for the Advice Show to do this press conference here. I think what we're seeing is that he's basically justifying the man that shot and killed a black man for defending his woman. In other words, he said it was a violent push, and the guy had like 4 seconds, and he shot the guy in the chest, and he ran back in the convenience store, and he died. Stand your ground law, in my opinion. I told you this from the beginning, that this is a major problem. Because number one, let's go back to the Trayvon Martin and the George Zimmerman case. George Zimmerman got out because of the stand your ground law. Because of the Trayvon Martin case, George Zimmerman went scot-free because of the stand your ground law. And then later on with the Marissa Alexander case, she was standing her ground with her alleged husband, threatened her. And she put out her gun, and she didn't even really shoot at him. She shot the gun in the air, and she served 20 years in prison for that. So in reality, ladies and gentlemen, is that what you're seeing is that this man's going to walk. Michael Sprague, the shooter that killed this brother who was trying to defend his girlfriend over a handicapped parking space. And basically, they were arguing back and forth. And this man, and then he at a press conference, the reporter asked him, do you think that he feels that his family's been threatening? And there's no evidence. There's no evidence to that. There's no evidence. Well, come on. If basically a man, it's like saying if you have a woman, right, and he feels that a man attacked this woman, and yet you have a nerve not to defend him. My conclusion is this, ladies and gentlemen, that we as a people have to accept this crazy law, and there's been stand your ground laws across the states. And it's basically ridiculous, and we already know this is ridiculous. But at the same time, until black legislators like congressmen and senators fight to abolish stand your ground law, incidents like this will continue to happen. Plain and simple. This young man lost his life today over protecting of his woman, defending of his woman, and he's a threat, so he shot him. So. And I'm going to tell you like this, if words were reversed, if a white man protect his white girlfriend or his white wife, and a black man approached him, and a white man pushed him down, and a black man shot him, what would happen to him? He would probably either receive he ain't going to get no stand your ground law. He might just do what Marissa Alexander did, get 20 years in prison. This is the double standard here in America of the criminal justice system that we're facing right now. Leave a comment. Tell me what you think about this video. Share this video. Subscribe to my YouTube channel. Subscribe to my reaction channel. And subscribe to my Black Johnson channel for my news and commentary. And with that being said, this is Lions Den signing off. Deuces.